Hello, Immigration Attorney Michael Ibrahim. Today, I want to provide you with some tips for when the Asylum Office does not approve your application. Many people come to the United States because they are unable to return to their home countries. United States and international law provide protections for these individuals. Generally speaking, somebody who fears return to their home country or native country has 1 year from the date of entry to file a Form I-589 asylum application. Please note that in some instances, the asylum application needs to be filed with the immigration courts. If in doubt on where to file your asylum application, contact and consult a U.S. immigration attorney. If you file your application with USCIS, you will be called in for an affirmative asylum interview. There are 3 topics of discussion at your affirmative asylum interview. 1, a review of the asylum application itself. 2, a discussion as to why you cannot return to your home country. And 3, mandatory security background questions asked of every applicant. Interviews can last several hours, but it is important to maintain focus and to explain all the details of your asylum. After the interview, the asylum officer will likely tell you that he or she cannot make a decision on your case that day. You will receive a decision in the mail. There are 2 possibilities after your asylum interview. Possibility number 1 is that the asylum office may approve your case and grant you asylee status. Possibility number 2 is that the asylum office will deny your case or refer your case to an immigration judge if you are no longer in lawful immigration status at that time. Of course, we always want to get an asylum application approved. But more often than not, in my experience, the asylum office denies or refers your case to an immigration judge, often for unfair or unjust reasons. Note that an asylum officer cannot deport someone. He or she can only deny your case or refer to an immigration judge for further proceeding. If your asylum application was not approved, there is no need to lose hope. There are options available. Assuming you were referred to immigration court, this is a great second chance opportunity to renew and buttress your claim. Applicants in removal proceedings continue to have access to work authorization. In immigration court, there's a lot more leeway and ability to offer evidence that may not have been available to the asylum officer. Immigration judges often like to hear from third-party witnesses, such as expert witnesses. Applicants in removal proceedings have slightly more control over their testimony. Applicants and their attorneys can often negotiate with ICE attorneys in these cases. Other forms of relief from removal or immigration benefits may open up during the immigration court proceedings. If you or a loved one are nervous because your asylum application is pending, or if you recently received some bad news from the asylum office, don't hesitate to contact the Ibrahim Law Office for a consultation today.